Good morning. It's Friday, February 10th. One of our top stories today is about a lawsuit filed against NMFS by 5 processors in Kodiak who participated in the Rockfish program. These are Trident, Ocean Beauty, Westward, Alaska Pacific Seafoods, and International Seafoods. We think the lawsuit is pretty important because it goes to the heart of the problem of whether shoreside investments and shoreside interest in the health of the processing sector is something that has to be considered under Magnuson. The plaintiffs, in this case led by Trident, argue that NMFS was wrong when they issued a legal opinion that said that the Fisheries Service had no right to consider the history of shoreside processors in developing the Rockfish program under Magnuson. They claim this is false and not true, and that NMFS should have to redo their current Rockfish plan because of it. But the question raises a larger one. You know, fishermen look at these IFQ programs where there's some kind of processor input and they say, why can't I just sell to the highest bidder? Processors, of course, are arguing that once you give the harvesters a monopoly over a certain resource, and you don't have additional conditions to it, they actually get all the value out of it because the overcapacity of the processors leads to an overbidding situation, which is true. And this can be documented in many fisheries. So let's go back to this argument. Why can't the harvester just sell to the highest bidder? The fact is, in an open fishery, they can. In an open fishery, let them go full bore, sell to anybody they want, do whatever they want to do. But once you get into a grant of individual fishing rights and you get into where you have ownership of fishing history, then you're not dealing with an open market anymore. The harvesters are getting a lot of the benefit that comes from fleet consolidation, from the ability to control the harvest, from not being subject to competition in the same way. And yet you cannot at the same time, in the processor's view, turn around and neglect any of the impacts that this might have on the processing sector. This has been, in fact, an underlying issue in every West Coast IFQ program, whether it's halibut and sablefish, crab, pollock, cod, whiting, Pacific groundfish, etc. And in each case, it's been dealt with in different ways. And this Kodiak lawsuit essentially says the Fisheries Service has got to address these issues. They can't just say there's no legal authority for them to do so and punt on it. And because it has the potential to set a legal precedent about how shoreside processing issues should be addressed under these management plans, we think it's quite significant. In Lexington, Mass., this is John Sackton.